Bringing it all together, applying the law in real life. Up to this point, we have built a strong foundation: supervision, delegation, discipline, and policy implementation. Now we shift into real-world application. This section is designed to challenge how you think as a broker by walking through common scenarios that occur in everyday practice. These are not theoretical. They are the types of situations that can either protect your license or put it at risk. The key to mastering supervision is not just knowing the law, but knowing how to apply it in real time. Referral fees and unlicensed activity, a common trap. One of the most misunderstood areas in real estate involves referral fees. A broker may be approached by outside businesses, such as moving companies, offering to exchange referrals for compensation. However, Arizona law is clear. You cannot pay compensation to an unlicensed person for activities requiring a license. Under ARS Paragraph 32-2153A-10, paying compensation to an unlicensed entity is a violation. Additionally, ARS Paragraph 32-2155 requires that a salesperson may only receive compensation from their employing broker. This was reinforced in Sherman v. First American Title Insurance Co., which clarified that only brokers may legally earn commissions. The takeaway is simple: if the person is not licensed, they cannot be paid. Supervision across brokerages. You cannot share responsibility. Another common scenario involves teams attempting to operate across multiple brokerages. While collaboration is common in today's market, Arizona law is very clear. Licensees may only perform real estate activities on behalf of their employing broker. This means that one brokerage cannot supervise agents from another brokerage. Even if the arrangement seems practical, it violates AAC R4-28306. This ties directly back to Section 1. Supervision must be clearly defined and controlled within the brokerage structure. Auctions, expanding the role of the broker. Many brokers are surprised to learn that Arizona law allows them to conduct auctions. Under ARS Paragraph 32-2101, a broker may auction real estate, businesses, and business opportunities for compensation. This highlights an important concept. The scope of a broker's authority is broader than many realize, but it must always be exercised within the framework of the law and proper supervision. Unlicensed assistants, where lines must be drawn. Unlicensed assistants are a valuable part of many brokerages, but they must operate within strict boundaries. According to ADRI policy, assistants may collect demographic information and perform administrative tasks, but they cannot discuss property details, pricing, or negotiate terms. This is a direct extension of supervision and delegation. If an assistant crosses the line into licensed activity, the broker may be held responsible under ARS, paragraph 32-2153. The lesson here is clear. Clear policies and training prevent costly mistakes. Marketing events and alcohol, managing risk beyond transactions. Even marketing events can create legal exposure. While ADRI does not prohibit serving alcohol at events, brokers must comply with local laws and ensure proper supervision. For example, if alcohol is served irresponsibly and leads to harm, the broker could face civil liability. This reminds us that risk management extends beyond contracts. It includes everything associated with your business operations. Broker price opinions, BPOs, understanding compensation flow. Agents often perform broker price opinions, BPOs, for lenders, especially in REO situations. Arizona law allows this under ARS, paragraph 32-3602, but compensation must still flow through the broker. This reinforces a key principle. All compensation earned through licensed activity must go through the employing broker. This ties directly back to earlier discussions on compensation compliance. Incentives and marketing promotions, staying within the rules. Offering incentives, such as free services or promotional items, is generally allowed as long as it complies with advertising rules and does not mislead the public. For example, offering a free car wash in exchange for completing a questionnaire is permissible, but it must be clearly communicated and not deceptive. Again, supervision plays a role. Brokers must ensure all promotions comply with the law. E&O insurance transparency, broker and agent responsibilities. Another important issue involves errors and omissions, E&O insurance. If agents are contributing to the cost of coverage, they may have the right to review the policy. This connects directly to Section 4. Your office policies should clearly outline how E&O coverage is structured, who pays for it, and what it covers. Transparency helps prevent disputes and ensures agents understand their protection. How this section connects. Moving forward, this section brings everything together by showing how laws apply in real situations. As we move into the next section, we will continue expanding on legal scenarios and risk management strategies. Each example reinforces the same core principle. Strong supervision, clear policies, and proper delegation are the keys to staying compliant and protecting your license. Online discussion. Question 1. Why are referral fees to unlicensed individuals prohibited in Arizona? Answer: because ARS paragraph 32-2153 prohibits paying compensation to unlicensed individuals for activities requiring a license, ensuring consumer protection and maintaining industry standards. Question 2. What is the biggest risk when using unlicensed assistants? Answer: the risk is that they may perform activities requiring a license, such as discussing pricing or negotiating, which can result in violations and broker liability. Question 3. Why must all compensation flow through the broker? Answer: Arizona law requires that licensed activity compensation be paid to the employing broker to maintain accountability, proper supervision, and compliance with ARS, paragraph 32-2155.